Hollywood is losing lawsuit claiming right to fire actress for free speech. Gina Carano's lawsuit is going to continue. That's what the judge overseeing the case just decided. Disney was trying to get the lawsuit delayed, at least until they could have an interlocutory appeal, which just means an appeal to a higher court to overturn the court's decision to not throw out the lawsuit. It's Disney's contention that they have the right to fire anyone who's working for them because even if it's against the law, even if it's against morality, it doesn't matter. Why? Because Disney claims, look, we're producing our own free speech. We're producing our own expressive content. So if we make a TV show, that's our corporation's right to free speech. You can't stop us from firing people who we think don't properly contribute to our free speech. Yeah, well, that's not necessarily clear, actually. There's another lawsuit going on that was brought by America First Legal on behalf of Brian Beneker, and that's against CBS Studios and Paramount. And in that lawsuit, he's a white heterosexual male script coordinator who was told, we're not going to give you a regular writing position because you're not the right skin color. We want to promote only certain skin colors. And that studio, Paramount, had a very similar defense. Their defense, and this lawsuit actually came before the Disney lawsuit, said that, look, we don't necessarily agree with everyone who's working for us, so we want people who work for us that agree with us, that have a certain skin color and cultural values writing our content, writing our TV shows. We're not required to hire this guy. The lawsuit says, no, you kind of are required to hire people based on merit. You can't just go around hiring people based on skin color for whatever reason. It's not legal. That lawsuit's continuing, and that's one of the reasons why in Gina Carano's lawsuit, the judge said, no, we're not going to throw this case out. And that was a few months ago. Just again, the judge decided, no, we're not going to allow Disney to try to appeal this case in the middle of the case so that the court above this court, the appeals court, could throw out the case and get Disney to not have to deal with this question. And this is not just Disney. This is Hollywood dealing with this question now. Do you have the right to discriminate against people because you can say, well, you're interfering with my free speech if I'm forced to hire people I don't like, if I don't agree with their political ideology? Hollywood would love for this case to go away, but it's not going away. And they're probably going to have a meltdown when this trial starts next year. From Deadline, Disney loses latest attempt to stall trial over Gina Carano's Mandalorian firing. Sex discrimination case goes before jury next year. And this is not just a case of Gina's free speech. They treated her differently than another male employee working on the same project. Disney also went out of their way to badmouth her in public. And that's a problem for an actor or an actress because that ruins their opportunity in the community. Even the fact that she's forced to bring this lawsuit can damage her in the future with Hollywood with future opportunities. I'm sure it's already caused her a tremendous amount of lost opportunities, not just this actress role on the Star Wars series The Mandalorian. As part of this lawsuit, Gina Carano is claiming Disney's out to misrepresent, malign, and mischaracterize her. And that goes beyond Disney criticizing her free speech. It's as if they were trying to ruin her for standing up to them. Her trial in her lawsuit against Disney is set to start September 29, 2025. After having beaten Disney and their legal team's effort earlier this year to get the Elon Musk-backed lawsuit she's filing thrown out of court, Gina Carano this week scored another win, with the federal judge overseeing the case denying Disney's request to stay the case, which would mean put the whole case on pause, while they filed an appeal with a higher court. Quote, having considered the parties' submissions, the relevant law, and the record in this case, the court denies this motion. In refusing to give the green light to Disney's hopes of taking the matter to another court and overturning her July 24th decision, that's the judge's decision, rejecting their motion for dismissal, the ruling has set the clock ticking on the trial. And this means discovery needs to start pretty soon. The trial is less than a year away, and attorneys need time to prepare, which means you need to give me a whole lot of evidence that I'm going to use against you in court. In fact, with her previous ruling being challenged by the very nature of Disney's latest motion and desire for an appeal, the judge made sure to knock down any notion Disney and its outside counsel may or may not have had of getting the upper hand. Quote, defendants do not, however, explain how a Ninth Circuit opinion affirming the court's order would alleviate the burden of responding to the discovery plaintiff has propounded to date, nor is it apparent to the court how such a decision could provide such relief. In any event, arguments regarding discovery, which the court notes were not at issue in the order, do not appear to have any bearing on the termination of the litigation and do not persuade the court that certification is appropriate here. In other words, don't waste my time, we're all adults here. So everything that Disney has done to try to personally discredit Gina Carano, to try to call her something terrible in public, ruin her career, delegitimize her claims, ruin her case, is not working. In fact, the judge may have tipped her hand to her take on all of this last month when she decided there would be no need for oral argument on either the appeal certification or the stay by lawyers. On September 19th, the case docket said no appearance necessary. If the judge would have allowed oral argument, it just would have meant that she was open to being persuaded. She wanted to hear both sides. In this case, she said, no, I don't need to hear both sides. We're not going to schedule anything. Forget it, Disney. You lost this one. With this new order from the judge allowing discovery to move forward, it means Carano and her lawyers will be getting a look soon at what went on internally at Disney 3 years ago in the lead up to the firing of the on-the-rise actress who played rebel shock trooper Cara Dune on The Mandalorian over views she expressed on social media and otherwise. Whether that leads to the injunction that will get Carano her job back is a whole other matter. Still, in also seeking a variety of unspecified damages, Carano took the win. Quote, I am obviously very pleased with the opportunity to keep moving forward with the judicial process and into discovery, she wrote Thursday. Quote, well, I wish this was not necessary, as it is not my desire to be in this battle in court. I will not shrink away from it because it's hard or uncomfortable. In its April 9th dismissal motion against Carano's suit over being fired from The Mandalorian, Disney insisted, as it had before, that the ex-martial arts fighter lost her high-profile Star Wars gig 3 years ago because of her decision to, quote, publicly trivialize what happened to Jews during World War II by comparing criticism of political conservatives to the annihilation of millions of Jewish people, notably not thousands, was the final straw for Disney. After portraying fan-favorite bounty hunter Cara Dune for 2 seasons, this all came to a breaking point when Carano shared a TikTok post in 2021 that looked to compare the current divided political climate in America to World War II in Germany. Responding in May, Carano's lawyer said, quote, after admitting that they discriminated against Carano for her personal political beliefs and subjected her to disparate treatment from her similarly situated male co-stars, Disney assert that the First Amendment to the U.S. Constitution gives them absolute immunity. Quote, defendants are incorrect. Clearly, to some small degree at least, the judge in the case agrees. Yeah, the First Amendment is important, and corporations do get the right to have their own free speech. That's great, but this is not exactly that. Let's check out the judge's actual decision. It's Gina Carano versus Disney. Some background. Plaintiff Gina Carano filed this lawsuit on February 6, 2024, asserting various wrongful discharge and sex discrimination claims after defendants, that's Disney, terminated her from the Disney Plus show The Mandalorian. On April 9th, defendants moved to dismiss plaintiff's complaint, contending that the First Amendment barred her claims. After considering the parties' briefing and oral arguments, the court issued its order denying defendants' motion to dismiss on July 24th. On August 23rd, defendants answered the complaint and filed the instant motion requesting the court certify the order for interlocutory appeal and stay proceedings in this litigation. As a general rule, parties, that's the defendant or the plaintiff, may not appeal a district court's rulings until after the court enters final judgment on the case. Why is that? Because if the judge allowed an appeal to a higher court to object to every judge's decision and everything had to be put on hold and then started again and then put on hold and maybe even go to a higher court beyond that, you couldn't really operate the case. It would delay the case indefinitely. As it is, cases like this could take a very long time to come together and get finished. And then beyond that, there can be another appeal. And then after that, there could even be another appeal. Defendants request this court certify the following question for Ninth Circuit review. Whether the First Amendment right to free speech protects an artistic entity's right, that would be Disney, or any Hollywood entity, to control its own casting decisions by declining to express its art through actors who make widely publicized statements that the entity deems offensive and harmful to its own artistic expression. Although it is not entirely clear from their motion, defendants may also seek certification of 4 additional questions. 1. Whether a court must defer, including at the pleading stage, to an expressive entity's concern that associating its art with speech it deems offensive would impair its own expression. 2. Whether an artistic entity has the right to consider an actor's off-the-job political speech when making casting decisions. 3. Whether the First Amendment prohibits the use of state power to control private speech through artistic equitable relief, but allows the use of state power to control private speech through monetary liability. And 4. Whether the First Amendment protections identified in cases like Green apply differently in the employment context. Defendants contend that the order held, quote, that the First Amendment does not confer on expressive entities the right to disassociate with performers based on their off-the-job political speech. As plaintiff correctly observes, quote, nowhere did the court make such a broad statement of the law. Indeed, the court explicitly recognized that defendants might, with a more developed factual record, be able to prevail on their First Amendment defense on some or all of plaintiff's theories of termination-related liability. The court will not certify for appeal a straw man argument, that means a kind of nonsense argument, conjured up by the defendants in an apparent attempt to create conflict between the order and the case law considered therein. Similarly, defendants mischaracterize a 3-sentence passage in which the court reasoned that, quote, the First Amendment may place certain limitations on the remedy plaintiff may seek for their claims. Defendants contend this material suggests that, quote, First Amendment protections against state interference with casting decisions depend on the remedy sought. Again, as stated by plaintiff, defendants missed the point. The court did not, as the defendants insinuate, reach the issue of what kind of liability might be imposed on the defendants if plaintiff were to prevail on some or all of her claims. Given the contours of defendant's motion to dismiss, such a determination would have been premature. And accordingly, the court did not make it. Because this conclusion is not contained in the order, the court will not certify the order for review on this basis. The judge also made the reference to developing the factual record. That means give us the discovery, give us the evidence to show what your decision-making was all about. Was it really about some free expression that you're entitled to as a creative corporate entity? Or was it something else? And also, why did you have to publicly slander this woman? Why did you handle things the way you handled them? You have attorneys. You know what you should and shouldn't be doing, Disney. You're a sophisticated company. What's your excuse? Let's see in the factual record. Maybe you'll win the case, but we need the evidence first, which Disney does not want to produce because they know it's not good for them. Finally, defendants argue that, quote, reasonable judges could disagree with the order's effort to distinguish leading cases on the ground that they did not arise in the employment context. Again, defendants misunderstand the court's order. In their motion to dismiss briefing, defendants asserted that 2 Supreme Court cases, Boy Scouts of America versus Dale and Hurley versus Irish American Gay, Lesbian, and Bisexual Group of Boston, established that the state cannot force an employer engaged in expressive activity to express its message through speakers who, in the employer's view, would impair the employer's ability to convey its own preferred message. The court's correct observation that neither Dale nor Hurley were employment cases was prompted by defendants' briefing, which implied that these cases arose from the employment context. Additionally, nowhere did the order articulate any premise that the First Amendment protections for expressive entities apply with less force, if at all, in the context of an employment lawsuit. Tellingly, defendants do not offer a citation to any portion of the order in support of this claim, nor could they because no such material exists. In sum, defendants fail to show substantial ground for difference of opinion. Additionally, the court will not certify for interlocutory appeal holdings not made in the order. Finally, defendants fail to establish that the questions which they seek to certify would materially advance the ultimate termination of the litigation if decided on appeal. Defendants argue that, quote, if the Ninth Circuit reverses this court, then the case is resolved in its entirety. As the court previously explained in its order, however, defendants' narrow focus on the question of termination overlooks plaintiffs' allegations concerning various conduct defendants engaged in before and after terminating plaintiff from The Mandalorian. And that's what this article was about. Gina Carano claims Disney is out to misrepresent, malign, and mischaracterize her. That is not just about a hiring opportunity. That is about destroying someone's reputation, which she made claims about in this lawsuit. That doesn't end the lawsuit. Even if there was no claim, if a higher court said, no, Disney can fire anyone they want to or hire anyone they want to based on the fact that they're a creative entity producing a creative work, and that creative work is protected First Amendment speech. That's okay, but you still can't go out and malign someone, and that's part of this lawsuit. That may remove those parts of this case if Disney were successful with that, but they're not going to be successful with that because the appeal is not allowed to go through. Even though if it did go through, there would still be a case that needs to get resolved. It would not end the case. Because the accusations about Disney's conduct maligning Gina Carano lack any obvious artistic or expressive quality, Disney's affirmative defense cannot be impenetrable. And Gina Carano's lawsuit would move forward with discovery regardless of how the Ninth Circuit might decide the certified questions. Any of the questions that the Ninth Circuit looked at would not prevent Gina Carano from pursuing the rest of the lawsuit. Give up the discovery, Disney. You're not going to get around it. Consequently, the court's decision to deny Disney's request to certify this case for interlocutory appeal is not only consistent with statutory law, but also with the well-recognized obligation of the judicial branch to avoid deciding constitutional issues needlessly. Defendants also assert that even if the Ninth Circuit affirmed the court's order, their appeal would protect defendants' constitutional interest in avoiding costly, speech-chilling discovery proceedings. Defendants do not, however, explain how a Ninth Circuit opinion affirming the court's order would alleviate the burden of responding to the discovery plaintiff has propounded to date, nor is it apparent to the court how such a decision could provide such relief. In any event, arguments regarding discovery, which the court notes were not at issue in the order, do not appear to have any bearing on the termination of the litigation and do not persuade the court that certification is appropriate here. In conclusion, for the foregoing reasons, the court denies defendant's motion. This case is not over. It is not a conclusion, but there is a major win here for Gina Carano and for everyone who's getting fired or losing opportunities like Brian Beneker because of the allegation that companies are making that, look, we're a creative entity. We create speech. We create creative products. So those creative products are protected under the First Amendment, even though we're a corporation. All of that's true. But it does not give you immunity to treat people any which way you want to. And whether or not you can decide to not hire someone because of their skin color or because of their political speech outside of your work environment, when you're part of a creative production, has not fully been decided. That's why this request by Disney was denied by the court. They're going to have to go through the legal process. Hopefully, Gina Carano is not going to be offered like $10 million or $20 million to resolve this in a settlement. If that's what she wants, though, it's her life and she's entitled to take the money. I'd love to see this case go all the way to the end. Let's see the discovery. Let's see this case proceed. I think she can win. She's got great attorneys and she's got a great case. Let me know what you think of all this in the comments below. Always love to see your ideas. Please be sure you are subscribed to the channel. Click the bell for notifications, give me a thumbs up, and I'll see you again soon with another story. And if I don't see you, I will miss you.